Welcome to Reducing Risk, a series of podcasts from Medical Protection created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medico-legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. This is a current series focusing on demystifying the Medical Council statements. And today we are talking about I Am the Best, a podcast on advertising. My name is Dr. Sam King and I'm one of the medico-legal consultants with MPS. And I'm joined today by my colleague, Dr. Lucy Gibbert, who is a GP from Taranaki. Welcome, Lucy.
Thanks, Sam. Nice to be here.
And we've also got Mr. Adam Holloway, one of the partners at Watt & Carney, our panel law firm. Always good to have you with us, Adam.
Thanks, Sam.
So let's talk about advertising. Given the severe medical workforce shortages we're currently experiencing in New Zealand, you might have tuned into this podcast thinking that the need for health professionals to advertise their services must be very small. But don't turn off now. The Medical Council makes it very clear that advertising covers a wide range of activities, including your practice website, and this could leave you vulnerable. So Adam, if I could ask you first, how does Medical Council define advertising?
They take quite a broad approach, Sam, in the relevant professional statement. They've defined it as any communication that is oral, in print, through electronic media, or on the internet, by or on behalf of a doctor to the public to provide information about the doctor's services, or the clinic or group where the doctor practices, or with which the doctor is associated. So I agree with you. What you mentioned earlier is that really a practice website would fit within that definition, and that's a pretty obvious first port of call in terms of information that a doctor or a practice might choose to publish. But it would also take in things that we more classically regard as advertisements, from a local suburban newspaper through to practices that might have a therapeutic cannabis component and have advertisements that come up on Facebook. So it's the full gamut. It's really if you're responsible for or connected with any information about your services, then you're going to be caught by the council statement and need to turn your mind to what the rules are.
Thanks, Adam. And staying with you about authorities, are there any other authorities that we need to be aware of when it comes to advertising?
Yeah, absolutely. So not only is there the council statement, which doctors will need to turn their minds to, but there's a whole body of just general commercial law around advertising, and this will include things like the Advertising Standards Authority, which you'll need to seek advice on if you're going to be publishing an advertisement, the Fair Trading Act, which can come into play if you are responsible for putting out communications that are false, misleading, or deceptive. And some of those general laws that all advertisers or all businesses need to comply with can have quite severe consequences of their breach. Not only can you make yourself vulnerable to a civil claim by someone who believes they have been misled and suffered loss as a consequence, but there's also an ability to be prosecuted and fined in some instances. And those fines can range up to $200,000 for an individual or $600,000 for a body corporate, like a company that you've set up to run a practice.
Wow, those are pretty hefty fines, aren't they? Lucy, would you mind just explaining whether MPS covers those fines?
Unfortunately, Sam, MPS does not, because it cannot, nor can any other insurance product. It's not permissible by law to indemnify or insure against fines. So look, your indemnity provider can cover costs, but we need to be clear at the start that advertising and website content is regarded as part of the business of medicine and therefore does not come under your MPS indemnity cover if there's a breach of the Fair Trading Act. So look, MPS would assist individual members if there was a complaint to the Medical Council, which raised conduct concerns, but no, MPS are not going to be paying your fine for under the Fair Trading Act, nor will we be assisting with any prosecutions under that Act, which we'd consider part of the business of practice, not a clinical concern.
Thanks for that. In the Medical Council statement that Adam was referring to earlier, it says any communication that is oral or in print on behalf of a doctor to the public. Lucy, as you know, clinicians regularly give pamphlets and information sheets to our patients. Do you think that comes under advertising?
I think if it's a clinical information sheet, I don't think that would come under advertising. Pretty much that advertising is something when it's about your product or your service. So I think if you're giving a patient an information sheet about the treatment of diabetes, I don't think that would be considered part of the standards.
Thank you. I know we get calls around testimonials that patients might put up on these review sites. Are we allowed to use those testimonials? You know, obviously the good ones, but no one wants to use the bad ones. But are we allowed to use those in our advertising on our websites? Because they would seem very helpful. Adam, do you have a view on that?
I think you need to be very cautious about testimonials, and if anyone was asking me for advice on compliance with the council statement or trying to reduce the likelihood of getting into trouble, I would say don't go there. The Medical Council's view is that testimonials can create unrealistic expectations of outcomes in patients, and must not be used or quoted in your advertising or on any website, social media, or other platforms you control that advertise your services. So, in essence, it's a no from the council, and that makes sense to me. It's if you look at the spirit of the council statement, it is really trying to make sure that the professional boundary between being able just to provide the best options and the best clinical care and present that information to a patient neutrally is not corrupted by a business desire. And as soon as you've introduced a testimonial from someone who had a particular form of treatment and for that individual achieved a particular kind of outcome, you're only going to make a rod for your own back if a patient comes and saying, well, I saw on your website that there was a testimonial from someone who got a great result from betamethasone. I want that too.
So, but like Google reviews, obviously you don't have control of those websites. So if somebody says something nice about you on a Google review, that's fine. But it's just that you can't copy and paste that onto your website. Is that right?
Yeah, absolutely. I've never seen the council take issue with Google reviews or things that crop up outside
the
of your
doctor's
control.
not in control of what is written on that.
That's right, and often those websites are in fact administered from overseas,
Yeah.
and most commonly we interact with those when someone's put something highly defamatory on them, and we're trying to have that taken down, and it's not an easy thing to do, unfortunately.
Can we just talk a little bit about negative reviews? And I know this isn't particularly to do with advertising per se, but we do get a lot of calls about that because doctors understandably get a little upset when patients put negative reviews, particularly if the patients haven't been particularly truthful in their account on that review. What do we do about that?
It depends first on whether it's obvious to the practitioner who the reviewer is. Sometimes you can deduce with some confidence who that might be, and sometimes you might not know at all. But there are options I would always start by seeking advice from MPS. We can contact the website host. That can be effective. It can also be difficult for some websites. Are easier to deal with than others, depends on which jurisdiction they're located in. You can submit a report to NetSafe and potentially apply for something called a harmful digital communications order. If you know who it is who's left that review and can demonstrate that, depending on what it is they've said, there might be an option for defamation proceedings, or even just what we call a cease and desist letter. So letting them know that they need to participate in taking that down, or they risk getting into further trouble. On occasion, unfortunately, the leaving a review is also part of a pattern of conduct that someone might have where they're essentially harassing a doctor or a practice. And we can help obtaining an order under the Harassment Act called a restraining order, where we go to court, show that there has been this pattern of conduct, and the court will order that person to stop. The advantage of that being that if the order is breached, then there's a clear way for the police to become involved and arrest the person for breaching the restraining order. So there are a range of options, but I don't want to leave listeners with the false impression that it's always possible to get unhappy internet reviews taken down. That, of all the different parts, that can often be the most challenging depending on which website you're dealing with.
And you're not allowed to ask your happy patients to leave reviews to push that review down, are you? I mean, that's part of this advertising statement, is you're not allowed to solicit positive reviews. So it's not like you can actually say to your other patients, please, could you leave some nice reviews?
You're right, Lucy, and I mean, it's an easy thing to say is just ignore the reviews.
Yeah.
It's not a normal distribution of your patients, people who choose to engage with those platforms. Focus on the people in front of you and doing a good job. And probably in New Zealand, the overall primary care environment is such that there aren't many doctors who are competing for patients, and so happily those sorts of things are less meaningful for us, but it would be a distraction and against the statement to engage in that sort of marketing process of trying to achieve an outcome with however many stars you get on Google.
I often say to our members that particularly in smaller communities, or in any community really within New Zealand, your reputation will be well known because word of mouth is obviously the best way that we build our reputation or destroy it. But so most people who read one negative review can often tell if it's a patient issue. You know, the patients often say things in a way that would demonstrate that perhaps they're a little unbalanced in their review, and that one negative review can't destroy a reputation of a doctor built over decades. And whilst it is upsetting, I think, for individual doctors, I agree, Adam, it's best to turn your mind to other things and not focus on it, because otherwise it just upsets you without, for no real reason, or for something that you cannot do something about. Lucy, I know that for practices who do have websites, or my Facebook, my knowledge about Facebook and those social media things is a little bit limited, but I'm presuming you can actually remove negative reviews if you want to. Is that right? And if you can remove a negative review, do you think that that's appropriate?
So I think most practices' websites don't have an area where you leave reviews on the website. So often those reviews are left on community posts or something where you're not actually the administrator that can remove them. So I think if you are in a situation where you could remove them, I think you need to address the problem. We often say if patients are making their complaint through that kind of system by posting something on social media, and you know who the patient is, we'd often say try and contact the patient and say, look, can we deal with this as a complaint through our usual channels, and try and avoid it that way. But I think in most situations the doctor is not in a position to remove negative reviews themselves.
I am aware of some practice managers who've contacted me who say that they are on their website
are they?
and they can remove them.
Oh, right.
And the
Okay.
issue is whether they should or whether that's appropriate. And where patients complain and they say, if you keep removing them, I'm just going to escalate my negative comments elsewhere. And I think that that's the key, really, is maybe that if you
Don't have reviews on your website, maybe
don't have reviews, but if you do get negative ones, to actually leave them, because the more airtime you give these people, often it just fans their flame, doesn't it? Let's move on to a slightly different area on advertising and in terms of our credentials. Adam, do you have any cases that you're aware of where the credentials presented by clinicians have got them into difficulty?
Yes, certainly. And I mean, the obvious example is one that hopefully wouldn't come up often, but every now and again we do assist members where there's been an embellishment or essentially an untruthfulness in terms of representing qualifications, and the council will treat that extremely seriously, because it goes to the heart of the trustworthiness of that practitioner. So it's a pretty obvious thing to say, but don't make things up on your CV would be a good piece of advice to follow, and hopefully not advice that will be relevant to many people. But more generally, the statement on advertising does have something to say about using titles and qualifications, and I think the spirit of it is that it is trying to disincentivize or quash the behaviour of people who might have a range of different certificates or qualifications which they put after their name, really by way of advertising to create the impression that they have a particular degree of expertise or ability to provide care. The way the council has chosen to pursue that aim is, however, quite draconian. And the statement provides that when advertising qualifications, you can only advertise those that appear on the Medical Council register or are conferred or awarded by your college or another training organisation that has been accredited by the Medical Council or by another New Zealand responsible authority. And by responsible authority, they mean an organisation like the Medical Council, but for physios or for pharmacists, etc. Now, taken at its face, that really just restricts you to your medical degree and your fellowship. But we certainly know that there are respected and respectable qualifications, postgraduate diplomas, for example, that people might undertake through the University of Auckland or Otago, that I think it would be difficult to characterise as what lawyers would call puffery. They're genuine, relevant qualifications that seemingly don't fit within that definition. I'd hope that you wouldn't get in a lot of trouble for using those, but it's a topic I think that we probably need to raise again with the council for the next time the statement is reviewed, to see if we can't move the dial towards being able to include those sorts of qualifications while still staying away from the puffery.
Because I think it's relevant for patients to know if a doctor has a diploma in palliative care or a diploma, and they are often, it's a reasonable thing for the patient to be aware of when making a decision about doctor that they want to see. So I think, those university qualifications, it does seem reasonable for doctors to use them in letters after their name, but it does seem from the council statement that really we shouldn't be putting our diplomas after our name on our websites or anywhere else, on our letterheads or whatever.
I wonder whether the Medical Council hadn't thought about the specific situations that doctors do find themselves in terms of their overseas qualifications. And I agree, it'd be helpful if we can have that conversation with the Medical Council next time they review their statement. There are some other things that the statement does touch on. Let's just have a quick chat about before and after photos, because I think for particularly the appearance medicine or cosmetic clinicians, they presumably do want to put before and after photos. Lucy, do you have any thoughts around that?
Yeah, look, the Medical Council are advising you think extremely carefully before including images in your advertising, and particularly before and after photos, because they have the potential to mislead or create expectations in patients of a successful outcome, or that the patient will get that outcome if they come to you. So look, if you are going to use before and after photos, you really have to ensure that they are only for the purpose of providing accurate and useful information, that they have to portray realistic outcomes that the patient can themselves expect, that they only feature patients who have undergone the advertised procedure under your care. So you can't use stock photos of what that procedure would involve. They must not have been altered in any way. The before and after photos must both be taken with the same lighting and contrast and background and framing and angle and exposure. So really, you've got to be really careful about how those two photos have been taken, and they have to be consistent in appearance, including clothing and makeup. And of course, the patient featured must have given their full informed consent. So there's quite a long list of things to consider if you are going to put before and after photos on. And look, it's an easy way to be tripped up, mostly because of that expectation thing. I think generally the before and after photos are likely to be good outcomes. No one's going to advertise bad outcomes, are they? But it may create expectations for patients that all the procedures that doctor undertakes will have those same good outcomes, and that's often hard to guarantee.
This advertising is not particularly straightforward, is it? When you see all the little bits to it. Adam, there are lots of doctors, well, I don't know about lots, but there are some doctors who have products that they use in their clinic and you can buy them through the clinic. I'm aware of some doctors who might be creating topical sprays or, something along those similar lines for their patients. What do you think the Medical Council's view on that is?
I think it's, again, a dangerous area, that if you are planning on selling products, it's something that it would be wise to get advice about before you proceed. And there can be a range of different ways that you could run into trouble. There's always the possibility of a poor clinical outcome and a complaint. And I think if it becomes part of that complaint, a focus becomes that the medicine used is something that you've had compounded yourself or have sourced and sold to a patient, then there's going to be a lot of questions asked about how confident you could be about efficacy and side effects, and whether the informed consent process you'd run through was appropriate or sufficient for introducing that sort of product. It might be that other council statements come into play, like the statement on complementary and alternative medicine, which has its own requirements. In terms of the Medical Council statement, they do have some paragraphs on endorsing medical products or methods of treatment within advertisements. And the statement provides that as a doctor, you should not endorse any medical products or methods of treatment in your advertisement. But I think that would really include choosing to offer a particular product to a patient in a consult over a range of other clinical options that you had in front of you. There's an obvious risk of conflict of interest where the treatment option you're choosing is one that you will also benefit from over and above the normal cost of a consultation. And I can't imagine that the council would be anything but quite concerned and likely to want to scrutinise that sort of interaction very, very closely. And in fact, the statement goes on to say in the next paragraph, if you are acting as an agent for or have a financial or other interest in a medical product or method of treatment, you must declare your interest within the advertisement in a way that does not endorse the product or method of treatment. Where that interest conflicts with or compromises the patient's care, you must advise the patient of the conflict and ensure that they have access to alternative sources of care. And there's another professional statement that the Council has about conflicts of interest that I think anyone involved in the selling of medicines or products direct to patients really needs to read as well and get advice on. So as part of the normal sorts of careful steps that any business person would want to go through before choosing to sell a product, the Fair Trading Act, the also informing yourself of the relevant council statements and pausing and seeking advice, I think would be the wise thing to do.
I think related to that is, for example, if you're a private specialist and you provide a particular service and then you refer them on to another service for part of their care, but you also have a financial interest in that, I think that very much touches on this whole area. And I know there have been some significant cases around that. I don't want to be too explicit about it because it just for anonymity's sake. But I think if you have any commercial interests that are in more than just one area, you do need to think about conflict and about being upfront with patients about your involvement, your financial involvement. Otherwise, it can get you into grief.
Yeah, absolutely. And I'm just trying to think of random examples rather than ones of cases we've had to deal with, but I can imagine perhaps a GP who also is a part owner of a rest home. And there's the clear potential for conflicts to develop. And so there is that other professional standard that you need to go and consult in order to help manage and reduce the professional risk attached with those sorts of conflicts.
Lucy, I know this is something that you've thought about. The Medical Council statement talks about not offering medical assessments or treatments as a prize or a gift. And would you mind just telling our listeners about scenarios that you might have come across?
Well, I think one that we got a call about was a doctor who ran a skin clinic who'd been approached about from their local hospice actually wanting to get a voucher from them for a skin check for a screen that they were going to use as part of as a raffle prize. So it was for charity, and the provider was going around multiple different organisations trying to get raffle prizes, basically, and so asked the clinic whether or not they would be happy to give a free skin check as a prize, and the question is that allowed under the Medical Council statement? Because the statement says you should not offer medical assessments or treatments as a prize or a gift where the objective is to make money and or to increase you and your practice's profile. So in this situation, they weren't going to it was going to be given away, so there was no making money. But is the objective to increase your practice's profile? Well, actually, the objective is you were approached to provide a voucher for charity, but it is going to increase your practice's profile. So you could and ah about that a bit. I think if you can show that it was for charity and you were approached, you didn't approach them, that you could probably argue that was not the objective, that you were giving it for charity. But you can see situations where you could be criticised for offering assessments as a prize. So you've just got to be a bit careful.
Do you have any thoughts on that, Adam?
Yeah, I agree. It's probably quite a common thing for somebody wanting to elicit a prize to say, well, and if you do give us this voucher, of course, we'll put your name on the ticket, or your logo can go on the poster for the raffle. Is it something that is highly likely to get you into trouble? Probably not at a practical level. But should it give you pause for thought? Yes, it should, because of those reasons that Lucy has run through, that it could be perceived to be that the choices you've made have been to raise profile rather than just do a good deed.
Thanks for that. I think we've covered quite a broad range of areas really within the advertising space that are covered by the Medical Council statement. So if we think about take-home learnings from today's podcast, Lucy and Adam, could I just have maybe 2 or 3 from each of you?
I think the thing when I read the statement is how broad advertising is, that it's not just an advert you put on the radio or in the paper. It's your letterhead, it's your website, it's, any kind of communication you're having with patients that involves them becoming aware of your services. So that's probably my take-home point, is don't just think of an advert as an advert in a paper, that actually your website is an advert, and actually as such it has to meet the Medical Council standards.
I guess I would say that it's interesting to think about how broad the council's remit runs. Not every doctor has the time to go onto the website and actually see what professional statements exist and regularly look at those. And people can be surprised that the council has turned its mind to these things and written a set of rules. So yes, there is a statement on advertising. It is worth having a look at. Yes, there is a statement on conflicts of interest that I think practitioners should be familiar with as well. And so the take home maybe is at a pretty high level, but it's to remember that as a member of this profession, there are things that you can get in trouble for which are one step removed from that very clinical context of providing good patient care in whatever specialty you're in. The Medical Council was also interested in your broader conduct and how you represent the profession more broadly.
Fantastic. Well, thank you, Lucy and Adam, for joining me today. And thank you for listening to this podcast. I hope it's been helpful. We look forward to catching up with you in our next podcast. And if you like the Medical Protection podcasts, please subscribe and leave a review. If you would like a podcast on a specific topic, please feel free to email us on nzpodcasts@medicalprotection.org. We'll catch you next time.